Hello, everybody, and welcome to today's webinar entitled Negotiating a Worry-Free Office Lease Agreement. My name is Sina Amiri. I'm a senior consultant with Cirrus Consulting Group. Many of you have received the invitation to today's webinar through Henry Schein Animal Health, and I'd like to thank them for promoting this educational presentation today. A couple of housekeeping items before I get started. I would like everybody to know that we will be recording this presentation, so that presentation will be available to you for viewing. If you have colleagues that have not been able to join us today, they'll also have a chance to listen to this program. Due to the high number of attendees on today's webinar, we will not be opening up the microphones to everybody, but you will have the opportunity to have your questions addressed towards the end of the presentation. And if you have a laptop or a tablet device and computer and you're logged in today, please do me a favor and, if possible, just kindly mute your microphones so there's no audio feedback for us and everybody can enjoy the webinar. So let's get started. What I'd like to first of all do is give you an idea of what we're going to cover over the next 50 to 60 minutes of this presentation, a little bit of background on who we are and why we're putting on this program, some alarming industry trends as far as what's happening in commercial real estate, in particular specific to veterinarians and animal hospitals and some of the trends we're seeing in the industry. Then we're going to ask a basic question, which is what is a lease and why it's so important. I think it's sometimes good to get back to the fundamentals of things. And one of the things we always like to discuss is why is the lease so important? A lot of times when a doctor's thinking about transitioning, relocating, or starting up an office, the lease agreement is seen as very transactional in the sense that you go through the negotiations, oftentimes thinking it's a contract, I'm signing it, and it's all about rent, and that's pretty much it. And my goal today is to actually introduce you to some of the $100,000 traps that hide in your office leases for those of you that are tenants, and also some key leasing considerations if you're planning on starting, buying, or selling a practice. We're also going to cover off what I call the tenant lease cycle, which is the process in which tenants negotiate leases and what strategies landlords use to delay the process. And then we're going to go over our 8-step process for beginning the lease negotiation if you're planning on renewing a lease or starting up a practice. This particular set of information will be very applicable to you. And we're going to actually teach you, hopefully by the end of today's presentation, some of the strategies that we utilize at Cirrus Consulting Group when we're negotiating leases with large landlords, small landlords, and different types of companies who own property across North America. And then by the end of this presentation, we will have a chance to take your questions. So as I mentioned, if you can kindly mute your microphones, if you have questions, we will make sure that you have the opportunity to have those addressed. You can either type those into the chat box, which I'll pull up at the end of the presentation, and alternatively, if you have questions, you're more than welcome to email me. My email address is on the bottom right-hand corner of your screen. Now, some of the industry trends that are happening in the industry, over 75% of veterinarians today have signed an office lease agreement that can actually prevent them from transferring their lease and ever selling their practice due to landlord interference. The animal health practitioners who engage in lease renewal negotiations without understanding complex lease provisions end up paying hundreds of thousands of dollars in unnecessary rent increases over time. And healthcare practitioners are really the least risky type of commercial tenant a landlord can have, primarily because of low default and bankruptcy rates. If you compare the average animal hospital to, say, a nail salon or a restaurant, the amount of investment that your practice makes in leasehold improvements is significant. And in fact, in comparison to some of these other types of tenants, you're spending, if not 200% or 300%, if not more than that, in building your office and equipping your office with the latest technologies. The benefit of having a veterinarian in the building, if you're a landlord, obviously not every landlord will see a direct benefit if the type of services you offer are not in line with the type of tenancy they're looking for. However, it goes without saying that you do offer vital service to the community. And having a veterinary clinic within a retail plaza, within a property, will attract foot traffic. And those potential individuals that come to your office with their pets will also be potential consumers of other products and services that co-tenants in your building offer. So there is an advantage or synergy, if you will, call it that, by having a veterinarian in a building along with some other co-tenants. And at the end of the project, if a landlord does negotiate a lease with a tenant, the goal is to obviously increase the value of the property long term. And we're finding that veterinarians generally are open to signing 10-year leases. And I'll talk about the term of the lease momentarily. And if you think about it from a financial standpoint, this is very attractive to a landlord. Not every type of business owner would be able to sign a 10-year lease agreement and give the landlord that level of commitment. Now, the reason why we're delivering the webinar today is that our company was founded by healthcare professionals back in 1994, and after the 1990s, essentially the firm evolved into a team of lawyers, a team of former landlords, and individuals that really have a deep understanding of how veterinary hospitals operate and what sorts of things they need in their leases. We analyze thousands of office leases each year. We've also represented over 1,000 practitioners last year alone. So in 2015, we were engaged in over 1,000 transactions involving landlords and tenants, and these include owners and occupiers of properties. So some of you on today's presentation are actually owners of your building. And we've also helped tenants, individuals that or hospitals that are not owners of the property they're located in, but are tenants of the facility. And we've successfully represented these tenants and negotiated their lease agreements with their landlords. So a lot of what I'm going to share with you today is a reflection of what I've learned being with the company over the last 5 years from having worked with so many veterinarians across the country. We've also negotiated over 12,000 office lease agreements over the past 2 decades. So since 1994, we have been involved in over 12,000 projects across North America and even as far as Australia. We conduct over 150 educational seminars annually, and we do participate in many veterinary conferences. In fact, you may have met me or some of my colleagues at these major industry conferences. And today we're proud to say that we are the premier healthcare tenant representation firm for veterinarians in North America. One of the reasons why Henry Schein Animal Health decided to partner with us is the fact that we are truly a national firm. We cover all 50 states as well as all Canadian provinces and territories, and we're able to negotiate leases anywhere in the country. So the knowledge I'm going to share with you is going to apply across borders and, in fact, across continents. And some of our customers, just in U.S. alone and some in Canada as well, you may recognize that we do work with dentists as well. Some of these doctors are actually physicians, but the ones that are highlighted here in orange, these are the ones that have recently hired us to get involved in negotiating lease agreements, and these are animal health practitioners. And the reason I bring up these particular clients is not every client that we deal with is in the same situation, as you can imagine. We have doctors, veterinarians that are owners of the property that they're located in. We have clients that are planning on transitioning, renewing a lease agreement, opening up a practice for the first time, selling an office. And so for every one of these clients, the recommendations we make is quite unique to them. We don't take the same cookie-cutter approach in negotiating lease agreements for, say, an associate looking to start their first practice as we do for a doctor who's in his or her 60s looking to exit and have a successful transition. And this is just a small subset of the projects we've worked on recently. You may recognize some of these names. They could be colleagues of yours. And then when we're looking at lease agreements, it's important for us to understand what is a lease. If you're planning on negotiating a lease agreement, you have to ask yourself a fundamental question, which is, if I'm planning on negotiating this contract with the landlord, what does it actually mean? And what I'm finding is a lot of doctors across the country, when they think about a lease agreement, they think about the fact that they're paying rent every single month to their tenant. As a tenant, they're paying that rent to their landlord. And the terms that come to mind when they think about lease agreements are primarily the financial obligations that are carried for many years. Having to pay rent every single year to your landlord adds up to quite a significant amount of money. Now, what a lot of practitioners don't think about is the fact that besides the financial obligations that are outlined in your lease agreement, there's also a lot of legal terms. And what I'm finding, especially even today when I was speaking with a few doctors, is that when you're negotiating a lease agreement, there's a tendency to focus on just the rental rate and the term of the lease agreement, and sometimes forget about all the fine print that comes with your contract. And what I've experienced is too many doctors being relocated unexpectedly because of the fact that they did not understand what terms the landlord had inserted into their agreement, which would give them flexibility to have them move to a different unit, or alternatively, to even evict them out of the building because of the clauses that they've agreed to. And so when we look at why the lease is so important, well, we know that it's a significant investment in cost today to build a veterinary clinic. We know that having a lease agreement is a foundation for everything else that you do. If you can imagine, when you come into the office on Friday or Monday and turn on the lights, what allows you to operate the facility is this contract, if you're a tenant, is this contract that you have with your landlord that stipulates that you have the legal right to deliver care within the premises, within the four walls of this building. But if that lease agreement expires next month and you don't have an option to renew, then your amount of predictability is only as long as the lease term. So what is the lease term that's ideal for you? And a lot of tenants, unfortunately, are in situations where their leases are coming up for renewal. Maybe they're expiring within the next 2 to 3 years, and they are not 100% sure what the landlord is going to propose to them upon renewal time. And knowing that it's a very difficult move, it's very important to be able to understand what leverage you have as a tenant ahead of negotiating the lease with the landlord, and not waiting until your lease is as close as possible to the expiration date prior to negotiating it. And that's really what landlords want. Landlords actually want you to get as close as possible to the expiration date of your contract, knowing that with 6 months or less of remaining term, you will not have significant leverage or as much leverage as a tenant who, say, has 2 years of term remaining on their agreement. And there's also going to be patient attrition. Anytime you move a clinic, whether it's a veterinary clinic, a dental clinic, or even a medical clinic, you can expect that a certain percentage of your patients are not going to be able to visit you given the geographic distance between where you used to be and where you are today. And for many doctors that even own their property, I know that when they're going through a transition, oftentimes a question comes up in that, what happens if I decided not to continue in this location and the buyer wanted to move the office? Would they actually buy the office and pay me the value I'm asking for if they don't believe that the geographic location I'm in is going to be helping them increase production over the next 5, 10, 15 years? And with some doctors that are in an unfortunate position of having to move unexpectedly because their landlord is not renewing a lease, or perhaps they're renewing and increasing the rent, the consideration to move is one in which the tenant has to determine how far away am I going to be able to move without affecting the production of the practice because of this attrition factor. Now, if you do negotiate your lease properly, there are some key attributes you should look for in your lease agreement. First and foremost, your lease should also provide you with fair and affordable financial terms. And what I mean by that is, are you agreeing to paying a set amount of rent every month? How is that rent going to increase over time? And out of the total rent that you pay, what percentage of that is basic rent and what percentage of that is additional rent? I spoke with the husband of a practice owner earlier today, and he explained to me that he had no idea that the $6,000 that he was paying every single month to the landlord, that a percentage of that was going towards the operating expenses, or the proportionate share of the operating expenses for the property. And he wasn't being sent detailed statements in regards to common area maintenance or operating expenses. And so the question that he was asking is, how do I even know that this $6,000 is accurate? If my basic rent is, roughly $3,600, there's additional rent I'm paying to the landlord, and yet I'm not sure how the landlord is spending that money because I'm not being sent statements. The lease should also provide you with long-term stability and security. Unless you're planning on relocating, the ideal term of a lease agreement is a 10-year term with 2 or 3 options to renew the lease for periods of 5 years each, therefore giving you between 20 to 25 years of predictability in the same location. At the same time, the lease agreement should minimize your risk and exposure, meaning if you're signing a lease, ideally you do not sign it under your personal name. Too many doctors that I advise have a lease agreement structured where they're the tenant as an individual, meaning they're not incorporated, and on the lease agreement, their personal name is on the lease. If they are incorporated, they've provided the landlord with what's called a personal guarantee or indemnity. What that means is that the landlord doesn't see the corporation as the tenant. They really see the corporation and the person, the doctor, as being jointly and severally liable for the payment of rent until the end of the term, and in some cases, even after the lease term has already expired, depending on what happens with the practice. The lease should also maximize your flexibility to be able to transition. Some of you on today's webinar have interest in transitioning your clinic to another practitioner. And when you do decide to sell the office, it's important to be able to assign or transfer the lease agreement to that practitioner without any landlord interference or any subjective determination by the landlord's part as to who you can or cannot assign the lease agreement to. And ideally, after transferring the lease, you don't want to have any liability for the premises. Now, I'm going to get into what is in the lease agreement because a lot of you had emailed us prior to the webinar asking us whether or not we would actually go through some of the terminology that's in your lease because a lot of it seems like foreign concepts to you. And the first provision I'd like to discuss with you is the option to renew. So for those of you that have a lease agreement today, for those of you that are tenants in your building, if you have a lease agreement, the question you want to ask yourself is, A, when does my lease expire? And B, do I have an option to renew? Now, generally, most doctors who have an option to renew, and many of them do, it's found in more than 90% of lease agreements, the option to renew, which is the provision that allows the tenant to extend a lease agreement by a set period of time. In most cases, it's 5 years. Generally speaking, there's a deadline for exercising the option. It could be 6 to 9 months or 6 to 12 months prior to the expiry date. And the landlord strategically sets the deadline for renewing the lease agreement to be generally a year or less prior to the expiry, knowing that if they set the deadline, say 2 years or 3 years in advance, you would be coming to them and have the ability to renegotiate the lease agreement and even ask for a rent reduction because there's enough time for you to plan for a contingency in the event the landlord doesn't agree to your proposed terms. Now, most tenants believe that if they have a lease, for example, I spoke with a doctor yesterday, the lease expired in 2019, or expires in 2019, July 2019. The doctor has an option to renew for one period of 5 years. And the doctor, because the deadline for the renewal is 6 months prior to the expiry date, the doctor's under the impression that she has to wait until the deadline to renew the lease. Now, what I'd like you to do before I answer the question of whether or not you can renew the lease agreement ahead of the deadline is take a moment and read this option to renew example on the screen and try to think of whether or not, if you were the tenant in the space, whether or not it would be to your advantage financially to exercise this option to renew, if you had such an option to renew in your own lease agreement. If you read this carefully, what you'll actually notice is that if the tenant exercises the option to renew, in no event will the rent actually decrease, meaning the rent will never go down. And furthermore, upon exercising the renewal option, what happens is the landlord basically gets to make a determination on what the rental rate would be. And if the landlord and the tenant cannot agree to the rent within 60 days, and keep in mind, this is market rent. This is not what you believe to be the rental rate. This is what the landlord defines in the lease. And most often, the market rental rate defined in the lease agreement is predicated on comparing your space to other built-out veterinary clinics and what they would pay per square foot for a fully fixtured office. So if you moved into your office and it was in vanilla shell condition and you spend $150,000 improving that hospital to be used as a veterinary hospital, the landlord actually factors in the value of these improvements when they're trying to determine the rental rate for the renewal terms, even though you're the one who invested in that improvement. After installation, those improvements become the property of the landlord. The other thing you'll probably notice if you read this option to renew carefully is that if this option to renew is exercised by anybody but the original tenant, it's null and void. In this case, what it states is that provided that Dr. Joe Black shall remain as the tenant, will the tenant actually be able to exercise the option. And what that means is if you're buying a practice and you happen to buy the practice from Dr. Joe Black and you go to renew the lease agreement, despite there being an option to renew in the original lease which was assigned to you, if you went to the landlord and said, I'm exercising my option to renew, the landlord's response would be, what option? You have no option because the option to renew was personal to the doctor who sold you the practice. Now, other times what happens when a tenant renews a lease is that landlord claims that because you've been in default of the lease agreement, you have no option. And the term default in and of itself is generally defined in the lease agreement. To the shock of most doctors, default doesn't occur just because you haven't paid your rent. There's numerous ways that you can find yourself in a position of default. For example, not abiding by the operating hours of the retail plaza that you're in. And those events in of itself trigger a default which results in the tenant losing critical rights like the option to renew the lease agreement. And we already talked about the fact that if you decided to renew the lease, the landlord gets to set the rental rate. In no event will the rental rate ever be decreased. But what's interesting with this example is that it states that any such renewal, meaning if you decided to renew the lease agreement, will be on the landlord's then current standard form lease. What this means is that, for example, if your building was sold and you're now dealing with a new landlord, upon exercising your option to renew, the landlord gets to place a lease agreement in front of you they've never seen before. And everything you had in your original lease agreement would evaporate by you simply exercising the option. Because the landlord has stated in the lease agreement, by exercising the option, you're agreeing to the fact that the landlord has the ability to present you with a new lease agreement that could be very different than what you've had in place historically. It could have clauses that you've never seen before. So exercising the option to renew in the majority of the cases isn't the best strategy. The right strategy is to approach the landlord ahead of the expiry and ahead of the deadline for exercising the option to renew and informing them of the fact that the lease agreement was engineered by them for their benefit and the fact that we need to make a fair deal happen. And because we have term left on our lease agreement, we want to renegotiate the terms well ahead of the deadline for exercising the option, knowing that if we wait until 9 months or 6 months prior to the expiry date of our lease agreement, we will be in a bind. We will not have the luxury of being able to move our hospital that quickly. Most relocations today take over 9 months. In many states and many jurisdictions, it's well over a year. And in this case, the landlord defines the market rent if you successfully decided to renew the lease agreement based on the rental rate for renewing tenants in the building. So if, for example, Starbucks occupies the end cap unit in your strip plaza, then the rental rate you pay will be affected by what rental rate Starbucks agrees to pay during their renewal. And you can imagine why this would be significantly detrimental to you because the businesses are not comparable. You cannot compare another retail tenant to a veterinary hospital and assume that both should have the same exact rental rate. Now, the next provision I'd like to bring to your attention is called assignment. And assignment provisions are found in roughly 3/4 of lease agreements that we review on an annual basis. And the assignment clause allows a tenant, if it's structured properly, to transfer the lease agreement to another practitioner. And generally what happens is the landlord gets to approve, meaning provide their consent, as to whether or not the lease will be transferred to another party. Now, the example you see before you states that if you require the landlord, if you're asking for permission by the landlord to transfer the lease agreement, you have to get the landlord to approve or give consent to the transfer. And what occurs in many cases is the landlord makes a subjective determination of whether or not they will allow the lease agreement to be assigned to another veterinary practitioner. If, for example, they determine that this individual who you're selling the practice to doesn't have the same net worth as you or the same practice history as you, those are generally sufficient grounds, meaning legally the landlord is in the right in the fact that if they decided not to assign a lease agreement, there would be no damages awarded to the tenant because the lease agreement is written in such a way that the landlord has flexibility to do what they want to do. In this case, what the landlord can actually do is either A, upon receiving your request to transfer the lease, turn around and terminate the lease agreement, or B, to revise the minimum rent to be paid during the remainder of the term, meaning upon assignment or request for assignment, the landlord can say, we approve the assignment on the condition that upon assignment, the incoming tenant or the assignee pays 8% more in rent. And these rights are generally built into the lease agreement, and most doctors are not aware of them until it comes time to transition the office. And if the landlord decided to renew the lease or assign the lease agreement, the key question here is how much flexibility does the landlord have in revising the rental rate? Despite the fact that you've signed a 10-year lease, if you assign a lease agreement in the year 7 of 10 and your lease agreement states upon assignment the landlord has to revise or has the ability to revise the rent, well, there's no guarantee that the buyer of the practice will have the same rental rate as you've had, and that may become a significant deterrent from them purchasing your office. And if you're like most tenants that are occupying space as a healthcare practitioner, chances are that your lease agreement states that even after the lease is assigned, you shall be liable for the failure of the assignee, meaning the doctor taking over the lease. If they do not pay the rent, you're still liable for the space. And this could occur for a period of time such as the length of the remaining term, or alternatively, sometimes it can actually go well beyond the length of the original term and be extended to so long as the tenant is in the building, meaning if you assign the lease to a doctor who plans on practicing in your space for 25 years, well, if you have liability in your lease agreement after assignment, you're liable then for the entire 25 years that doctor practices within your former premises. And there are many other traps in lease agreements. I don't have time to go through all of them, but if anybody is interested in understanding these terms, and understanding how they impact your hospital, feel free to contact me, and I'd be more than happy to discuss and help you define what these terms mean. And for those of you that are looking at buying or starting a practice, in terms of starting a practice, there's a couple of things you need to absolutely negotiate. In speaking with a doctor last week, we had a chance to discuss the fact that she's looking at opening up a new clinic, and the first thing that came to mind was rental rates. You know, are you going to be provided with fair rental rates, and how do we define fair? What are we basing that on? And are you being provided as well, in addition to the basic rent, are you being given a tenant improvement allowance? Meaning, is the landlord willing to contribute financially to the cost of the build-out of your clinic as far as price per square foot? Furthermore, we also want to have an extended fixturing period. If you're building a clinic, you're not going to be able to switch on the lights and be operational tomorrow. It can take you several months to actually construct the office. And knowing this, the question is whether or not we actually pay rent during the time in which we're constructing your office. And I'm finding too many doctors are agreeing to short fixturing periods because the broker who's representing them is not aware of the length of time necessarily that it's going to take to build a clinic. And furthermore, unfortunately, because they don't have any experience negotiating leases for veterinary clinics, that broker may not understand why it's critical, if you're signing a long-term lease agreement, to get a lengthier fixturing period, especially considering how much money you're investing into the property and how long you're going to stay there in the building for many, many years. And then there's a fine print, which is the lease terms and conditions. You know, if you're being represented by a broker, understand that they get paid a commission by the landlord, but they're not going to act as your legal counsel. So you need to make sure that you have the right legal professionals on your corner who are thoroughly reviewing the contract for you and advising you on the terms and provisions that are not going to only impact your startup in the next 6 months of your life cycle, but are going to significantly impact your ability to be able to renew the lease later on or be able to sell the office many years later. And if you're planning on selling a practice, you want to have lots of term on your lease. The average practice purchase today requires financing. And what that means is if you're planning on selling your practice, you'll need to make sure that you give the buyer at least 7 years, ideally more, of predictability in your space. So if you're planning on selling the practice and you have a few years left on your lease agreement, it's critical to think about whether or not you should extend the lease agreement ahead of the transition to guarantee that the buyer is able to practice in your location. You also want to have options to renew that are not personal to you. We discussed this. And if you've provided a landlord with a personal guarantee, if you're now in your 40s, 50s, 60s, or 70s, you want to understand whether or not the landlord is willing to remove that guarantee. It's in your best interest to remove that guarantee ahead of transitioning, because if you have that guarantee and you have liability after assignment, then there's personal exposure. And on assignment, you want to make sure that the landlord does not use subjective criteria during the assignment process, meaning when you decide to assign or transfer your lease agreement, the landlord cannot say no for any subjective reason. There has to be a very defined way for the landlord to give consent, and generally that process should entail, A, are you selling a practice to a corporation or individual who's licensed to deliver veterinary care? And B, is that person able to get financing to acquire a clinic? It should not matter that that person has $150,000 of student debt. It shouldn't matter that that individual has only been practicing for 3 years, because this profile is very typical of a buyer today. I mean, many buyers buying clinics are not in their 50s and 60s today who are in the net worth range of over $1 million. That just doesn't happen. So you need to make sure that the landlord has reasonable criteria in the lease agreement that allows you to easily transfer the lease to another practitioner. And last but not least, you need to have an early termination right in the lease agreement in the form of what I call a death and disability clause, which allows you to be able to terminate the lease agreement by providing the landlord with advance notice. Should you become ill and not be able to practice your profession, or God forbid if you were to pass away, you want to have the ability to have your estate terminate a lease agreement without any ongoing liability should your estate not be able to sell the animal hospital. Now, some of you have asked in the past whether or not it's a good idea to start negotiations when the option to renew deadline comes up, whether or not you should do so beforehand. And as I mentioned in the early part of today's webinar, the ideal time to negotiate a lease agreement is not when your deadline is for exercising the option. Although we've been extremely successful in helping doctors that have a lease term of less than 12 months remaining, I will say that it's generally a good idea to start negotiating a lease agreement at least 2 to 2.5 years prior to the expiry. If you start the process really early, the worst that they think that can happen is the landlord could say to you, sorry, it's too early, we should negotiate this later. Sometimes landlords do that as a tactic because they know that the vast majority of veterinary practitioners, they oftentimes forget about the fact that their lease expires by a certain date, and so if they delay the negotiations, you may actually forget about the fact that your lease is coming up because life's going to take over and you're going to be busy looking after your patients, and so you won't have another chance to revisit this until it's too close and the landlord has a lot more leverage. And there are also a lot of doctors that we speak with that have a handshake agreement or alternatively whose leases have already expired, and the best advice I can give to you if your lease has already expired is to reset the clock immediately, meaning obtain some term. If you're planning on moving, you should still have at least 6 to 12 months of remaining term on your lease agreement. So think about signing a shorter term lease if you're planning on moving, but don't put yourself in a position where the landlord dictates when you have to get out of their building. And I mentioned earlier in my introduction that I was going to go through the 8-step process that we follow when we negotiate lease agreements. The first step that we go through is we gather all the documentation. So we will want to make sure that we're looking at the current lease agreement. If there's a lease that was signed previously that was assigned to you, we want to have a copy of that, and also look at any legal amendments that you've signed. Then we want to identify your practice goals and your career goals. And you can go through the same exercise if you're planning on renegotiating your lease agreement. Sit down and list out what your objectives are as both a practice owner as well as an individual who's going to be in the office, and maybe you decide to sell it, but you may decide to remain on board. How's that going to look like 2, 3, 4 years, 5 years down the road? The third step in our process after going through the phase of gathering the documentation and identifying our goals is we want to go through the lease agreement line by line, and we want to basically identify what provisions are in our lease. And so we want to look at the assignment clause, we want to look at the options to renew, we want to look at all the terms. After we've looked at the terms in our lease agreement and highlighted those provisions that are important, we want to prepare with market research. This is where we will go out and look at rental rates and vacancy rates in our market. We'll want to look at what other tenants are potentially paying for similar space within a reasonable distance from our office in reasonable type properties, and then come up with a strategy as to what rental rate we're going to ask for ahead of calling the landlord. And after doing that, we also want to define what other objectives we have and what outcomes we want. So for example, is the ideal outcome for us to negotiate a 10-year extension so that we can sell our clinic within the next 2 years, if our goal is to transition the office shortly. Other times we may be in the earlier part of our career, and so our goal may be just to reduce the rent as much as possible and also have some predictability by not being relocated or forced out of the building. So what are our objectives? After we've gone through steps 1 to 5, and if you think about it, steps 1 to 5 do not require any direct communication with the landlord, which is pretty interesting because most tenants, they have a tendency to want to call the landlord immediately prior to doing any research, prior to even preparing for what they're going to negotiate with the landlord. And it may come as a shock to many of you, But even though we've been in the business for 22 years, we generally take up to 2 full weeks, preparing for one lease negotiation with one landlord. And the reason why we do that is because there's no better way to negotiate a lease agreement than be armed with the information that's going to help you win and also make assertive arguments as to why the landlord should agree to the terms that you're asking for. And once we've done our research, we will contact the landlord and we'll negotiate their rental rates first ahead of negotiating legal terms. And you may wonder why, despite the fact that I said that the legal terms in your lease agreement can oftentimes cost you more than paying an additional $1 or $2 a square foot. It's because when you're dealing with a landlord, most landlords understand that in order to run a building profitably, they need to make sure that they are given a fair market rental rate, meaning the rental rate that you're paying is in line with what other landlords are getting. And because of this, if you approach the lease negotiation by negotiating legal terms first, most landlords will not be as interested in negotiating with you because you haven't really addressed what is front and center for them, which is what are you going to pay me in rent and for how long. And you'd be surprised how often once you get that negotiation out of the way, the landlord is a lot more open to listening to the arguments you're going to make as to what legal terms you want in your lease agreement. And when it comes to legal terms, realize that if you present a landlord with a laundry list of legal changes that you want in the lease without properly structuring those changes in the form of legal amendments, you will most likely fail because the landlord, generally speaking, doesn't want to have to take your business requirements and pay an attorney thousands of dollars to translate those requirements to legal terms that are only going to be enforceable with a veterinary tenant. If the landlord has different types of tenants, you can imagine that it's not cost effective for the landlord to negotiate and draw up 12 custom lease agreements for 12 different types of businesses. So if you're planning on changing the legal terms within your agreement, what you want to do is you want to work with somebody who can actually submit and draft the legal amendments that the landlord wants to see and have the landlord approve or not approve those changes. But sending the landlord a list of items that are not properly structured from a legal standpoint doesn't really get the landlord interested because they realize that you're not a lawyer and you're presenting legal terms. You have no idea what the consequences of those terms are for your business, let alone the business of the landlord, which is for them front and center. After negotiating the legal terms, we want to get a final copy of the lease agreement and sign that lease. Many doctors that have signed a lease agreement, unfortunately, have failed to get a signed copy of that lease agreement back from the landlord. And we've seen situations where landlords evicted a tenant. Why? Because the lease agreement that they have has actually not been countersigned by the landlord. And because the landlord never signed a lease agreement, technically, although you've signed a lease agreement, you're obligated to pay the rent. But as far as the landlord is concerned, you very well may be a month-to-month tenant. So make sure that if you're going to sign a lease, you actually get a countersigned copy back from the landlord and put that lease agreement somewhere safe so that you can refer back to it. And if something happens to the property and you need to file an insurance claim, there's a copy of the lease agreement that you have in your records with both your as well as the landlord's signature on it. And to summarize today's presentation, the key takeaways from tonight is the fact that if you have a lease agreement, the details in your lease agreement can cost you hundreds of thousands of dollars if they're left alone. When you're negotiating a lease agreement, it's not just about rent. There's other things that you need to focus on, especially things like minimizing risk, maximizing flexibility and practice value, and achieving long-term peace of mind by having a long-term lease agreement in place. And you also want to be strategic. If you're going to sell the practice within the next 3 years, the first thing you bring up to the landlord should not be the assignment clause, because once you do that, the landlord is going to understand this is important to you. And you want to be strategic. You also don't get what you deserve. You do get what you negotiate into your lease agreement. So many of you have been fearful in the past to ask for changes in your lease because you believe, and you've convinced yourself to believe, that just because you're leasing 2,000 square feet and the tenant next door happens to be leasing 5,000 square feet and you're dealing with a multi-billion-dollar institution of a landlord, you don't deserve the changes that you think you should have because of the small footprint that you occupy. And we're shocked to this day about how many doctors that retain us find out later on, after we negotiate our lease agreement, what changes the landlord has agreed to, despite the fact that in some cases they're leasing less than 1,000 square feet. It's really about making sure you ask for what you want and arm yourself with information that you need to obtain those changes. And you're not going to be able to obtain those changes, though, however, if you don't sign the process, if you don't start the process, and you don't get ahead of the signing of the lease agreement until you're actually ready, but also make sure that you're starting the process early. You're not waiting until the last minute to sign that lease agreement. Because if you do so, realize that the landlord knows that you don't have the luxury of moving easily, and so for them, time gives them the type of lease that they want. It doesn't necessarily give you the type of terms you need. And as I mentioned earlier, you want to do your homework, so have a plan in place and execute on that plan. Now, what I'd like to do, given the fact that we have about 8 minutes left on this presentation, I'd like to open it up for Q&A. So if you're in front of your computer or your tablet device or your phone, please take a moment and post your questions for me, and I will try to get to, ideally, as many of them as possible. And if I don't get to your questions, please don't hesitate to send me an email if I don't get to your question, and I'll try to address it within the next few days. So I have a question here, and the question is, how do I research what market rates are in my area? So excellent question. The first thing that you want to do is you want to have a look at the websites of brokerages in your area, which often have listings, and you want to find some comparable buildings in your area and determine what those rental rates are for these properties. So what I mean by that is, if you go on the website of, say, Cushman & Wakefield or CBRE or any of the top brokerages, you'll often find a ton of listings. And so what you want to do is a search on your city or your town, and then try to find some ideal properties to compare your space to, and have a look at what the rental rates are. Now, a lot of times when you're looking at a listing on a space, realize that the listing is the ideal rent that the landlord wants. It's not the actual rent. So in this case, my recommendation would be, if you want a more accurate assessment, find somebody who can do the market research for you. It is something that we offer as a company, and momentarily I'll actually tell you how you can obtain some free market rental rate numbers so that you can do a bit of research on your end and have something to go with. So I will get back to that question a little bit later tonight, but for those of you that need some comps, the good place to start would be to look online. And then alternatively, what you could do is you could speak with colleagues of yours. Just be careful if you're doing that, because if you're speaking with a colleague who's negotiated a lease agreement, there is a sense of confidentiality, and they have to protect that confidentiality. So make sure that you understand there is this confidentiality clause in most lease agreements, and the client can tell you what their landlord specifically agreed to, but they can maybe tell you whether or not your rent is higher or lower than theirs, but make sure you're comparing apples to apples. If they're in a situation that required a lot of build-out money, that may have been factored into their rental rate. I have another question here. How does leasing an already existing practice with an established name factor into a lease agreement versus simply leasing a rental space. So I think the question I have for you is whether or not you've bought the practice, because there's absolutely a premium in rent that a practice with an existing brand will generate over, say, leasing a rental space that has not had a veterinary office in it previously. So I would be more than happy to have a look at your lease and kind of talk to you about your situation in particular to find out whether or not this particular practice, which is existing, has a rental rate that's comparable to leasing a space that's not built. And keep in mind that if you're planning on purchasing a practice, clearly there's a bit of a premium you pay for that over a simple build-out of an office from scratch. And how many miles, I have another question, or how many miles away would be considered kind of my area in a suburban area if I'm planning on, I guess, doing a comparable analysis of rental rates? And the answer is that generally speaking, we look at a 2 to 3 mile radius. So I wouldn't necessarily be looking at rental rates beyond 3 miles unless you're in a not so densely populated geographic zone. But for the most part, 2 to 3 miles is ideal. In places like San Francisco, obviously you're looking at something of a half a mile or 1 mile, given the fact that if your search is a broader area, you're going to come up with too many properties and you can't do a good comparison. So I'll wait for some other questions to come in, and I'm pleased to let everybody know that given the fact that this webinar has been co-sponsored by Henry Schein Animal Health, we will be offering the first 5 attendees who contact Cirrus with a free 30-point lease inspection and a personal coaching session, if you will, where we'll schedule a call with you to go through your lease agreement and also address any questions you have over a 1-hour phone call. So my telephone number and my email address is there. There's a lot of people that attended today's webinar. Unfortunately, we can only offer a complimentary lease review to the first 5 due to scheduling constraints. But that being said, if you do have questions and you are not one of the first 5 people to raise your hand, we'll try and get back to you at our earliest availability. And if anybody has any other questions, our website is also a great resource. So let me go back. I'll put this slide up again, but let me just go back to the Q&A window just to check the questions. And I'll get to your questions. If you haven't been able to get an answer to your question, feel free to follow up with me. But again, for the first 5 attendees that reach out to us, you will be provided with a complimentary lease review since I haven't been able to get to all of your questions. And if anybody has any input they'd like to give us or any feedback, we always welcome it. And we look forward to hosting more of these webinars in the future.